As a licensed second-hand vehicle dealer, you now have new rights and responsibilities toward your business and your customers. These are contained in the Cooling Off Rights Amendment Act and the 2010 regulations, which have amended the Second-Hand Vehicle Dealers Act. There are some key changes for you and your business. Consumers now have a cooling off period. Purchasers can waive their right to cool off if they want to take their vehicle away immediately. There is a new scheme for licensing salespersons. The definition of a dealer is changed. Airbags are no longer exempt from the duty to repair. There are new record-keeping requirements, and there is an increase in fees and penalties. There are also changes to the forms that you currently use, as well as 5 new forms that deal with the cooling off provisions. To learn more about these forms, visit our website for the Office of Consumer and Business Affairs. Just click on the home page, look for the Second-Hand Vehicle Dealers heading at the top of the page and follow the links.
G'day mate, I'm Dave.
Damien, good mate.
Out looking for cars today?
Under the new laws, purchasers now have a cooling off period of 2 clear business days, including Saturdays, to change their mind about any contract they've entered into to buy a second-hand vehicle. If the purchaser pays a deposit, it can be no more than 10% of the purchase price. During this time, you retain legal title and physical possession of the vehicle. The purchaser can cancel their contract, but they must give you written notice before the expiry of the 2-day cooling off period.
Damien, good to see you again.
Good to see you. Just like to give you this.
They can do this personally, by post, by email or fax, or by leaving it at the dealer's place of address with a responsible person. If the purchaser has paid a deposit under the contract, then you must give it back to them by the end of the next clear business day. You are entitled to keep $100 or 2% of the contract price, whichever is less. Under the new laws, the purchaser is entitled to waive their right to cool off by signing a waiver form. This is a new form and it requires a witness, but it can't be signed by you as the dealer or any salesperson involved in any way in the sale. It can be signed by any person that is with the purchaser or anyone in your car yard who is not involved in the sale.
Wonderful, thanks.
And make sure that you do not induce the purchaser to waive their cooling off rights.
I can knock a few dollars off the price if you're willing to waive your rights for the cooling off period.
The decision to waive cooling off rights must be the purchaser's.
I'm happy with the car. I want to take the car now.
Morning, sir. I'm Val.
Under the new laws, you must not sell or offer to sell a vehicle that is subject to a cooling off period.
But I have to let you know this car is under contract subject to a cooling off period.
The only thing you can do is offer the purchaser an option to purchase the vehicle if the contract for the sale of the vehicle is cancelled.
So if the other client decides not to proceed with the purchase, you'll be happy to go ahead?
You have a right to ask the option holder to pay a deposit of $100 or 2% of the contract price, whichever is the less. The option holder will only have a right to purchase this vehicle if the first purchaser cancels their contract during their 2-day cooling off period. If the option holder also changes their mind and decides not to go ahead, then you can keep the deposit.
Well, tell me about your experience in customer service.
When appointing staff to the dealership, you need to be aware of the new laws. The candidate might seem like the perfect person for the job, but have you done the necessary checks? Under the new laws, you must not employ a person as a salesperson if they have been convicted of an indictable offence of dishonesty, if they have been convicted of a summary offence of dishonesty during the last 10 years, if they have been suspended or disqualified from practising or carrying on an occupation, trade or business under any law operating throughout Australia.
Megan, I'm ringing from Madley Vehicle Centre.
You should ask questions, speak to referees and do a criminal history check to make sure you fulfil your responsibilities under the new laws.
Wonderful.
If you don't, or if you knowingly employ someone as a salesperson who fails the eligibility tests, you could be facing a fine of up to $100,000. Beware though that this does not apply to salespersons you have already employed unless they are convicted, suspended or disqualified after November 29, 2010. If a person buys or sells any vehicle in the course of a business, they must be licensed as a dealer. There is no change to this requirement. However, under the new laws, there are changes to who is presumed to be a dealer if they do not have a license. From now on, you will be presumed to be a dealer if you sell or offer to sell, or buy or offer to buy 4 or more second-hand vehicles in 12 months, and you aren't registered as a dealer. And you can't just get a relative or flatmate to help you out. If you and a close associate sell or offer to sell or buy 6 or more second-hand vehicles in 12 months, and neither of you is registered as a dealer, so what is a close associate? Under the new laws, 2 people are close associates if they are directly related, in the same household, in partnership or are joint venturers, related bodies corporate, where one is in a position to control or influence the conduct of the other, where one has a right to share in income or profits from a business of the other. Make no mistake, you will be busted if you operate as a vehicle dealer without being licensed. Do the right thing and make sure you follow the law.
So you had a test drive, what did you think?
It's not too bad, but I'm concerned about the brake.
You continue to have a statutory duty to repair defects present in the vehicle or that appear in the vehicle after the sale. Previously, airbags were exempt from that duty. However, under the new laws, airbags are no longer exempt. You will now be obliged to fix a defect in the airbag if the purchaser brings it to your attention during the sale.
And the seats are very comfortable for you as well?
Often you may purchase an unroadworthy vehicle as part of a trade-in. If it's not financially viable to repair the vehicle to a roadworthy standard for sale to the public, you may sell the vehicle to a wrecker. Previously, there was a lot of paperwork to comply with this process. You no longer have to do this. Under the new laws, you can sell unroadworthy vehicles to a wrecker for the purpose of being wrecked or disassembled for salvage without having to comply with these 5 notices. There are minor changes to the current forms that you use. Numbers have changed, references to calling off rights and last owner details have been added, and airbags have been added to the list of items that you have to repair. There are also 5 new forms which must be used after November 29. The first is for a purchaser to use when they want to waive their calling off rights. The second is for varying certain conditions during the calling off period, such as legal title, access to vehicle and roadworthiness. The third is for recording the details of the condition of a trade-in vehicle. The fourth is for you to cancel a contract on the grounds of a change in condition of the trade-in vehicle. And the last one is an option to purchase being subject to a contract of sale.
You can take a look at the forms and learn more about the changes to the laws for second-hand vehicle dealers by visiting our website for the Office of Consumer and Business Affairs.